Suzanne Bassal is an attorney, and she completed law degree from the University of Tennessee, and she has a degree in broadcast and journalism and Spanish, and she's currently practicing attorney in the Phoenix area. She has 3 children and a husband, and she was a member of CNN White House unit, serving as youngest member of the White House Press Corporation. She covered President Clinton, Bush, Arab League, senators, congressmen, and she witnessed history of making in Florida, recount, Camp David, and many other events. She also corresponded for CNN Radio, and she was the media director for Life for Relief. Islamically, she has been board member for and legal counsel for Arizona Cultural Academy since 2010, and she was elected as an attorney for the Sandra Day O'Connor House Domestic Violence Volunteers as an attorney, and she also volunteers with the Leaf Collective, which is an organization out of California that brings new Muslims, converts to Islam and supports them. So, Sister Suzanne Bassal.
Assalamu alaikum. Jazakallah khair, Dr. Tamir. It's very hard to follow, mashallah, Dr. Tamir, who has been, mashallah, serving AC in the community for many, many years and has a wealth of knowledge. And I was asked to speak about LLCs, corporations, and nonprofits today. And I will just preface that I'm not an expert in the area, not a corporate attorney, but I did have to study it for the bar. So I do know a little bit about it. I have had to actually help incorporate or file paperwork with the Arizona Corporation Commission a few times for different corporations. Okay, and so the topic today, so I'll be discussing the difference between LLCs and corporations, in particular C Corp and the S Corp. And then I'll also just talk about the importance of incorporating as a nonprofit. And then, as Dr. Tommy mentioned, I will briefly discuss kind of perks and limits on perks of directors for nonprofits, inshallah. So here we go, LLC versus a corporation. So the difference between an LLC and a corporation, it's complicated when you're looking at the fine details of both legal entities. If and when you're forming one, you definitely want to seek the advice of an accountant or an attorney to decide which entity would best suit your needs. So the difference between an LLC and a corporation, I'm talking the legal entity, which is the way the courts and everyone else sees the corporation, or the sole proprietorship partnership versus a C corporation and S corporation. This is really the tax entity. Sorry, am I putting my hand in front of that? Sorry about that. Which is the way the IRS and the state taxing board sees the business. So a corporation will be given a tax designation, either a C Corp or an S Corp. The default is a C Corporation, which we'll discuss the advantages and disadvantages of that, unless you specifically file a form to become an S Corporation. So an LLC actually has a choice on what tax identity it wants to have. It can be a sole proprietor partnership, or it can actually be taxed as a C Corporation or an S Corporation. But as you'll see a little bit later, that's a lot more paperwork. So now I'm going to discuss kind of taxes in the C Corporation. So the major disadvantage to the corporate designation is its double taxation implications. So corporation, the profit's taxed once, so the corporation, whatever, say they make $300,000 profit, that's taxed, a corporate tax. Then the dividends its shareholders receive is again taxed, so they're taxed for an individual tax. So if there's $300,000 in profits, and then that's taxed at a tax rate, and then the dividends are, say, $66,000 for each person, they're again taxed for the corporation. So that's the major disadvantage of a C corporation. With an S corporation, you have flow-through taxation, so no corporate tax. So again, if we use the same example, the $300,000 in each, the dividends, say there's 3 shareholders, they get $100,000 each, so they're just going to be taxed on that amount. So you were really just taxed one time. So depending on the circumstances of a corporation, though, it may have no choice but to be a C corporation and face double taxation. For example, you actually have to be you have to be a U.S. citizen to be an S corporation, or all shareholders have to be. So if you have someone who doesn't have citizenship, obviously you don't have it, or you want to issue a lot of shares and you don't know who's going to be purchasing, then you may have to be a C corporation. An LLC can choose how to be taxed. So by default, it's treated as pass-through entity, single taxation. So whatever, if there's one, an LLC can be one person. You can just, maybe some of you have businesses. You can be the main, member or manager of the LLC, and you're just going to be taxed at, it's going to be your individual tax. It's going to be taxed, not the corporation.
What does LLC mean?
Limited liability company. I should have probably stated that. I apologize. So a limited liability company can elect to be taxed as a C corporation or an S corporation if it qualifies. Again, there's a lot of other requirements, such as you have to have meetings, and so it's a lot of paperwork that small businesses really probably don't want to deal with. So both LLC and S corp, as we mentioned, have flow-through taxation, no double taxation. LLC's distribution of profits is subject to an employment tax. S corporations' dividends are not. So small businesses, like I mentioned before, can avoid significant employment tax by electing to become an S corp, but it is a lot of paperwork. So now we're looking at business ownership. Ownership of a corporation are the shareholders. Owners of an LLC are its members. So an LLC has complete freedom to distribute ownership stake to its members without any regard to capital contribution to an LLC. Meaning it can, one person, you can have two people come in, one person puts in the money, the other one is putting in time and effort, but they can be 50-50. And that's okay, it doesn't matter, they can split, profits 50-50 or however they choose to, and there's no requirements, regarding with the government in how they have to distribute profits. Corporations can theoretically do the same by creating a unique stock class, and that's really in the C corporations. They have like Class A stock, Class B stock, but S corporations, which do avoid double taxation, cannot do this. They have to create a unique stock class structure, meaning that basically however much money you put into an S corporation is how much you're going to get back. It's how much, dividends is going to be in proportion to your initial investment. So with regard to business operation, an LLC has a more centralized management structure. Any member may act as an LLC's manager. An LLC, again, can elect to have no distinction between an owner and a manager of the LLC. A corporation must have a corporate structure, so they have to have a board of directors, which handles the management responsibilities, and corporate officers, which are handling the day-to-day operations. And I guess it's similar to what Dr. Tamia was talking about with regard to a board who doesn't really handle the day-to-day operations of the organization. They're more, management, and then corporate officers, which could be in a nonprofit staff and so on. They handle the day-to-day operations. So shareholders as a class are considered owners of corporations, but they do remain separated from the business decisions, except for major corporate decisions. And they do retain power to elect directors, and a shareholder can be elected as a director or appointed as an officer. So the legal discrepancies between an LLC and corporation is that LLC is kind of considered the new kid on the block. It's only been since the 1970s that we've recognized LLCs, and they were kind of like this, taking on attributes of both the corporation and sole proprietorship. But generally, some state laws in some states are different regarding LLCs, so you have to consider that depending on where you're at. Whereas a corporation, they want to call it old, predictable senior citizen. It's been around for centuries, and laws are uniform for the most part in a lot of states regarding corporations. So now I guess we're going to turn into looking at nonprofits and the pros and cons of incorporating as a nonprofit. So again, the benefits of a nonprofit are that there's no taxes. As a nonprofit, your organization is eligible for state and federal exemptions from corporate income tax plus other certain taxes. And as we all know, ability to receive public and private donations. It's 501c3, and you can receive grants and donations, and individual donors can claim personal income tax deductions, and bequests are exempt from federal and state taxes. Bequests are just where people, pass away and they leave money to an organization. That's actually exempt from federal and state taxes. Again, your protection from personal liability. If someone is driving a company car or is doing something for the purpose of the company or for the nonprofit, and God forbid they're in an accident, then your assets are protected, especially if you have liability insurance, which, as Dr. Tomei stated, would be highly recommended. Then they can just sue, or sue the company for assets, but they can't really attack you personally or your personal assets. So a lot of people obviously incorporate for protection and having personal liability. I do want to mention, though, that this is not an ultimate blanket exception. In companies, you think board of directors are always protected, but if if negligence or something on the part of the board can be found, it's very, very difficult, but they call it piercing the corporate veil, where a court would actually allow a board member to be sued personally or be held liable. It's a very difficult standard to meet, but I just wanted to let you know that is there. But for the most part, you have liability insurance, and they're not going to, get past that, inshallah, if anything happens. Organizational perpetuity. So obviously the organization lives on. And with regard to employee benefits, when you have a nonprofit, employees can have health insurance. As a group, they can have pension plans. It's not available to unincorporated organizations. And then there's corporate structure. It forces the group to be clear about its mission, about its operating rules, and procedures for decision making. So with nonprofits, we call it articles of incorporation. When you incorporate, for example, with the Arizona Corporation Commission, and you have bylaws which also are controlling that the board can form. Of course, other benefits are exemptions from county and real personal property taxes, lower postal rates on third-class bulk mailing, and cheaper advertising rates, or ability to air free radio and public service announcements. I bet you probably didn't know that, PSAs. I don't know if there was some way, I don't know actually whether, for example, CARE, when they were doing those ads or commercials about Muslims and what Muslims look like, whether they were able to probably get some of that for free because it's a public service announcement, and showing. And so,
I wonder if religious organizations are included, or religious organizations are catering to a segment of society, not the whole society.
Sure, he was saying a religious organization that's catering to a certain segment may not be able to get a PSA, but if they were able to do something that served a greater good, maybe they could, in the smaller maybe radio station, get something on. Disadvantages, again, are a lot of paperwork, costs. Sometimes hiring a lawyer to prepare your papers, time and energy to comply with your regulatory demands and to grow your organization. And as Dr. Tomei mentioned earlier, there's a lot of paperwork and filing, and you're going to be examined with a fine-tooth comb and magnifying glass, and so you want to make sure you dot your I's and cross your T's. Another disadvantage, of course, or advantage if you look at it, because not having paid for your directors ensures that you're getting people who are obviously, inshallah, committed to the cause and to the mission. There's no political campaigning or lobbying, so if you're a 501c3 organization, you cannot endorse a candidate, you can't, in any way campaign or lobby, because that could risk you losing 501c3 status. And if an organization falls, its assets must be given to another nonprofit. And I'm going to just touch on, directors are required to perform their duties in good faith, with ordinary care, and in the best interest of the nonprofit. And in regards to perks for directors, the Federal Volunteer Protection Act, this is not on the slide, but is what protects board members from lawsuits. So once the members start to become, or to look like employees, by whether they take perks or something that becomes questionable, you are subject to being sued. You start to lose that protection. So board members often do get privileges like free dinners. Thank you all for the dinner, it was good. Paid trips to seminars because they're not paid, and it's not unethical to receive some privileges. However, there's been mentioned, for example, a $500 limit per benefit in terms of how much of a benefit are you getting, how much is it worth per year, and so when it surpasses that, it becomes questionable whether you're a volunteer or whether you're an employee. And of course, you want to also make sure you protect the 501c3 status, which also does not allow board members to be paid or receive excessive benefits. So I think that is all in my presentation.